everyone. Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance. I'm Jeff Mahoney, General Counsel of CII. My special guest today is Kobi Kastiel of Tel Aviv University, Harvard Law School, and the European Corporate Governance Institute. Professor Kastiel is the co-author of a recently issued research paper entitled The Courts, Legislation, and Delaware Corporate Law. Welcome, Professor Kastiel. Thanks for taking the time to speak with us today.
Welcome. I'm delighted to be here. Thank you very much for the invitation.
Professor, your research examines the Delaware General Assembly's amendments to Delaware General Corporation Law from 1967 to 2025. What motivated you to conduct this research on the Delaware General Assembly's impact on Delaware corporate law, and what were your key findings?
Yeah, it's a good question. So let me just clarify in the beginning. As you mentioned, this is a joint work with my colleague and longtime friend, Professor Asaf Hamdani from Tel Aviv University. And we started to think about this subject 3 years ago after the settlement in the Boeing Caremark litigation case. It was the first time that there was a high monetary amount settlement in Caremark cases. And there were some concerns in the marketplace that premium will rise, insurance premium, of course, that there will be not enough coverage for this type of claims. And then what the Delaware legislature did, they passed an amendment to Delaware law that went below the radar and was done extremely fast, within a few months, and permitted companies to have a captive insurance, so to have a subsidiary that will act as an insurer and address this type of lack of insurance concerns. And when we look at this amendment and the way it was done, and both of us have taught in the US for many years, we started to think also about different amendments from the past that we remember. And we say this could be a really nice topic to examine in a broader historical perspective, legislative amendments that are responsive to court decision in Delaware. You know, we had a first draft of this paper ready just a week before the proposed legislative amendment post-Morris decision came out. And then the topic exploded and everyone started to look at this and it became the hottest topic in corporate law. But what we were hoping to do in this paper is to situate this recent hot debate in a broader perspective by examining the interplay between court and legislator in Delaware over a period of 6 decades. And we go all the way back to 67. And what we do is we uncover a consistent pattern of legislative responses to the judicial decisions. We show how these responses aim to address critical challenges that are inherent to a system like the Delaware system, which is rely on judge-made law. So there are various challenges, including the tension between norm setting and isolating corporate insider from out-of-pocket liabilities so that it will be easier to recruit them, the limitation to fiduciary-based adjudication and how to carve out exceptions to those, and other institutional constraint of the judiciary. For instance, they have to wait for the parties to bring the cases, changes can take time, and in all of those situations, we provide a framework showing how legislative interventions are conducted. We also show how this interplay between courts and legislation allows Delaware to adapt to stakeholder pressures to mitigate the risk of federal intervention or other threat to Delaware dominance. But, and there is an important but here, we also show that through frequent or openly contentious legislative overrides could undermine Delaware's dominance by threatening judicial independence or raising concern about the effect of interest group politics in Delaware corporate law, which shows why the picture is becoming more complicated.
Professor, I found your discussion of the Delaware General Assembly's 2006 amendment to Section 141B of the Delaware General Corporation Law of particular interest because it involved the core corporate governance issue of majority voting for the uncontested election of directors. Can you provide us with some background and an overview of Section 141B and the 2006 amendment, including how the amendment was impacted by the 2001 Enron scandal and the Sarbanes-Oxley Act of 2002?
Thank you. It's a really interesting question. So in 2006, the Delaware legislature amendment section 141B, as you mentioned. And the aim of that amendment was to clarify that the director may tender an irrevocable resignation that is effective upon a later date or is contingent on the occurrence of a future event. And these resignation letters are essential complement to effective majority voting policies, because even if in the presence of majority voting policy, an incumbent directors who fail to receive majority support can remain in office until a successor is elected. So if we want to have these policies effective, we need these resignation letters, and majority voting is an important measure of accountability from shareholder perspective, right? But before the amendment, it was questionable whether a director, as a fiduciary of the company, could irrevocably agree to tie his hands or to resign based on future conditions. Fiduciary law that requires director to exercise discretion all the time makes things a little bit complicated here, and the amendment resolved this uncertainty. Now, the amendment, this relates to the second part of your question, the amendment was passed in the wake of the Enron era scandal, and in the face of increasing pressures from institutional investors, including from your organization as well, from the CII, to give shareholders more power to discipline board of directors. That was one of the major lessons from that scandal. And what the CII pushed for was to have majority voting policy as a default arrangement for Delaware corporations. The legislator didn't accept that, but they use the letter of resignation so that it will make these policies more effective if companies decide to adopt them through private order.
Professor, your research paper indicates that the Delaware General Assembly's amendments to Delaware General Corporation Law in 2024 and 2025 were, quote, unusual, unquote. Can you first provide our listeners with some background and an overview of the 2024 and 2025 amendments? And then can you explain why and how those amendments were unusual?
Sure. So both the 2024 and the 2025 amendments were highly controversial. A lot have been said about them. It could take us a whole hour to discuss them, or even more than that. So I'll be very brief about the amendment themselves. The 2024 amendment was introduced in response to the high-profile Mollis decision that invalidated provisions in an agreement between a corporation and its founding shareholder. In that case, the agreement required the board to obtain the founder's consent before considering various actions, and limited the board discretion over the board size, and required the board to ensure founder representation in all committees, etc. And the court held that the combination of this provision was facially invalid because it infringed the board duty to exercise independent discretion under Section 141A. And the post-Mollis amendment basically authorized companies to enter into the Mollis type shareholder agreement, and it came after a reaction in the marketplace. Company says there are many agreements that exist. It's a common practice, and they asked the legislator basically to revise that case, to amend the law. The 2025 amendment eases constraint on related party transaction, including related party transaction involving controlling shareholders, by overturning a substantial body of case law and doctrines in this area. Among other things, the amendment to Section 144 provides safe harbor provisions for controlling self-dealing transaction, except in the context of freeze-out. So if those transactions are approved by either a committee of independent directors or a majority vote of the shareholders, they will be subject to relaxed judicial review and basically will be immune from any legal challenge. And there are other pieces to this amendment. I won't get into all of them, but it's important to note that this amendment was passed in response to growing concerns about the corporate exodus from the state. We can debate whether those concerns were justified. And again, momentum following Tesla high-profile reincorporation in Texas after the Delaware Chancery Court decision that voided Elon Musk record compensation, the $56 billion package. Now, what we show in the paper is that there are several notable differences in the dynamic underlying the 2024-2025 amendments compared to previous legislative amendments. So just to give you an example, we show how these judicial overrides, legislative overrides of court decisions become more and more frequent in recent years. Historically, there was a notable gap between court decision and the legislative response. Here again, we see that the legislative process become much faster, despite calls to slow down the process in the two recent amendments. For instance, just to show you that the 2024 amendment, it came even before the Delaware Supreme Court had the opportunity to review the Chancery Court decision. It's the first time in history it happened. Unlike all prior amendments that were passed unanimously or with one vote of dissent, in these two cases, we see fierce opposition at the different stages of the legislative process. They lack the typical consensus building process that existed in past amendment. The amendment also challenged the long-held assumption about harmonious relationship between the Delaware legislature and the judicial branches. And lastly, and maybe most importantly, the 2025 amendment also deviated from Delaware tradition not to intervene with core fiduciary duties, the scope of judicial review. They find ways to get around it in prior amendments. So this is another important change. I think the real question here is to see whether those are just two outliers or this is the beginning of a different trend.
Professor, in the section of your paper entitled Institutional Investors, you state, quote, even when factoring in the alleged reduction in shareholder protections, Delaware remains a more attractive option to investors than Nevada, unquote. Can you explain the basis for your conclusion that Delaware general corporation law is better for investors than Nevada?
Right. So in this conclusion, basically we rely on widely accepted notion among commentators, academics, experts of corporate law that Nevada, by and large, provide lax corporate law and have fewer protections to investors compared to Delaware. But the important point that we wanted to show or to convey in this part of the paper is the basic concerns that investors face in those situations. So the way it works is that insiders, they basically control the decision where to incorporate. And this gives them credible leverage when proposing any legislative reforms. And because the incorporation business is important, Delaware legislators have strong incentives to be attentive to these insiders' lobbying effort as long as they are not too radical, too crazy. And the problem is particularly acute in controlled companies, where the controller can threaten to reincorporate from Delaware to Nevada or Texas without the approval of shareholders, to do it unilaterally, basically. And with such a background threat, institutional investors who are dissatisfied with the recent legislative development have very limited recourse. There is very little they can do. Because even if we factor the alleged reduction in shareholder protection because of the recent two reforms, SB 21 and the post-Mollis amendment, there will still remain more attractive options to investors compared to Nevada. That's the basic notion. That's where we started. And I think what happens here is that the 2024-2025 amendments reveal a significant asymmetry in the design of corporate law that's aligned with the rest to the bottom theories. And we discussed this to show the problematic position of institutional investors when we understand this dynamic. Now, maybe there need to be some structural changes to address it. So think about changing the composition of the council, the expert body was in charge in proposing and corporate law amendments in Delaware, and maybe institutional investors should have a seat at the table there. This is something that we'll have to discuss in future research, but we stress on this point just to show the catch-21 of the institutional investors.
And Professor, just to follow up to that answer, in the concluding section of your paper, you raise several questions about the potential impact of the controversial 2024 and 2025 amendments to Delaware General Corporation Law. One of the questions you ask is whether large institutional investors will try to influence Delaware's corporate legislation in the future by avoiding investing in companies incorporated in Delaware. So how would you answer your question?
Yeah, thank you. It's an interesting question. So I think that to avoid investing in Delaware, investor needs a viable alternative. And I don't see any other state that could seriously compete with Delaware, right? If we consider all the major points discussed in the literature, right? The network effect, the expertise of Delaware judges, their ability to conduct speedy trial, to provide first-rate services to companies, to conduct fast adjustment to corporate law, as we have shown in the paper. If we consider all of this, I think that many will agree that there is no real alternative to Delaware, that Delaware will continue to dominate on that end, that investors will continue to invest in Delaware companies. I think the real question here is whether investors will be able to use the magical IPO moment to ensure or to secure certain protections, including protections from the ability of controllers to move to Nevada unilaterally midstream. That will then limit the bargaining power of the controllers vis-a-vis the legislator. With respect, this is directly related to my prior answers. So I think that's the most interesting question going forward, and we'll have to see how things will play.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to thank my special guest, Professor Kobi Kastiel, Tel Aviv University, Harvard Law School, and the European Corporate Governance Institute. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, Jeff, at CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to The Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.